All right, thank you all for being here. I appreciate you staying with us here for this next panel. The next panel here is titled PTAB Review, the most important decisions of 2024. Now, I will confess that this is my title, and I hope it's not too misleading. I'll tell you what I have in mind, and I had real trouble trying to figure out how to capture it into a title. This is not necessarily only going to be about decisions, quote unquote, written opinions or that sort of thing. I think over the last year there were a number of decisions that were made. Some of them were made not to do anything, and some of them were made to try and do some things that didn't go through, and some of them were kind of, in a lot of ways, I think in my opinion, we'll get the take of the panel here in a minute, wound up being a lot of big nothing burgers along the way. So that's what I wanted to talk about. What happened during the last year or so at the PTAB that mattered, and the decision not to do something I think might be as interesting to talk about as decisions actually to have done something, and is also important decisions that were made by the PTAB themselves. So that's what I have in mind for this, is just moments of consequence. That probably would have been a really good title. Why did I think about it while you're all staring at me right now? Moments of consequence at the PTAB. Okay, so when we broadcast this as a webinar, that will probably be the title of it. So let me introduce the speakers that we have here for this panel. First, we have Ingie Osman, and Ingie is a partner at Latham & Watkins in their DC office, and she leads the firm's patent trial and appeal board practice team. Thank you for being here. This is the first time you've been with us, so thank you very much.
Thank you for having me.
Next to Ingie is Scott McEwen. Scott is probably one of the most prolific practitioners at the PTAB. He's been doing it for a very long time. He's at Wolf and Greenfield. He is also the chair of this particular program now for the 5th year. He's a good friend of mine, so it's always a good excuse to get together with Scott. And he is also the author of PatentsPostGrant.com, which probably everybody in the industry knows about. So Scott, thank you very much for being here. And next to Scott is Judge Jay Moore. Now you're just Jay, right? You're just JJ, just Jay. Judge Moore was on the PTAB for all. You were there when it was just the board too.
I was 22 years.
So, and then he was also the first vice chief, right? And you were acting chief for a period of time at the very beginning of AIA trial practice, and now he is of counsel with Buchanan. So, thank you for being here, Your Honor.
You'll note he didn't say I was his friend.
No, he is.
We are, however, a proud sponsor of
yeah, no,
IPWatchdog.
you are. You're a very good sponsor, and I would say you're a friend too. You give me the business more than most. So
just the way I am, I guess.
Yeah. No. So, and actually, maybe you can answer me this. Why does the patent office? Why do they keep updating inter-parties re-exam? You were on the panel, right? That was the last inter-parties re-examination. Do I have that correct? Weren't you many years ago now?
Inter-parties re-exam, didn't that go away?
Well, I thought it did go away, but they keep, every time they update the MPEP, they just updated that chapter last year.
I can't imagine there might be some left. You never know. There might be. The procedures for those were awfully complex.
Yeah. Okay. All right. Great. So, well, thank you all for being here. What I'd like to do is we can go down in the order in which I introduced you to get your preliminary thoughts, to kind of what our appetite for what it is that we're going to talk about during this panel. Ingie, when you hear the moments of consequence or important decisions, what over the last year or so really stuck out for you, and why?
Sure. So I do think there are a lot of really interesting decisions or moments of consequence in the past year. I think the not one decision maybe, but a couple of decisions that I think are really interesting and important are the ones that have to do with discretionary denial per General Plastic and Valve. So there were a couple of direct review decisions, one Ford v. Neo Wireless and General Motors v. Neo Wireless, and then addendum, where the director explained the application of the significant relationship test that was outlined in Valve and kind of gave more predictability and consistency for petitioners, which I think is really helpful in terms of setting expectations for how petitions would be viewed and how discretionary denial would be applied. Those rules made it into the notice of proposed rulemaking, but as we heard from the prior panel, that didn't mature into a final rule, and we're sort of waiting to see what will happen with that.
Yeah. Okay, good. Good place to start. There's a lot to unpack there in more detail. But Scott, your first thoughts?
I guess, and I would echo that I think those decisions were probably the most noteworthy. But to me, maybe it was the presidential election, because I don't know that those decisions will be good law in a year. Especially when you talk about the discretionary practices, 314A in particular. A lot of what Director Vidal did with respect to the PTAB was to focus on that. In particular, I think she may have considered that somewhat of a mandate, given some of, I think, her early backers. Senator Leahy certainly did not like some of the things that were going on with discretionary denial. So a lot of the focus, especially in the director review decisions, the memo that came out quickly after Director Vidal took the seat was all about sort of recalibrating 314A. So to me, it's looking back on those decisions and what they're going to mean going forward, because my expectation is we'll get another pendulum swing in the other direction.
Are you predicting another pendulum swing here coming up, or?
I think we'll probably go back to the FinTIV type practices that we saw under Director Iancu. That's my expectations.
Okay. All right. More to unpack there, but Jay, your big picture, what do you see that
I'm
matters?
a nuts and bolts guy, right?
Yeah.
So the PTAB, well, there was a recent director review decision, and it's actually the only one of its kind. It's the appeals review panel, and it's ex parte Chamberlain in May of 2024. And to me, that's a really important case. And everyone's going,
I thought so too. No, I thought that was a big case.
And the reason I like that case, and I think they've done something there that I want to keep seeing, is the transparency of that decision. How did we get here, right? Because that kind of case could come up to the director any number of ways. And I like, and you were talking about FOIA and responses to that. You just want to know, how did we get here? And that decision lays it out nicely. So that's, I'm tending to lean towards the director review processes in our discussion here.
Okay, good. So, so where do we begin to unpack? I mean, maybe we start with what, Ingie, you said. We don't have a panel on real party and interest, although I was surprised. I thought we would. I didn't have any takers, but I thought that was, in talking with you, Scott, also, and reading your blog, that was probably one of the biggest decisions of the year, I thought. So, Ingie, since you brought it up first, fill us in on why that matters so much, and maybe even a little bit about the case, so everybody's on the same page.
Sure. So you referred to it as real party and interest, and I think it's related, but the way the cases are structured, at least the Ford v. Neo Wireless and the General Motors v. Neo Wireless, those cases are really more directed to 314A general plastic application. So they expand on of course, the valve significant relationship test, and the question for Ford versus Neo Wireless was, when Ford didn't have a relationship with the other party who had previously filed an IPR. There it was Volkswagen who had previously filed an IPR. The panel denied the petition initially based on Volkswagen's prior IPR, and Ford requested director review. In that decision, the director looked at the facts and said, Ford didn't have a significant relationship with Volkswagen, it actually was a direct competitor. And to the extent that they were working together as a result of a judge's mandate. They were mandated to participate in the same multi-district litigation and the same MDL, and the judge mandated that they work together on invalidity contentions. And so as a result of that, they did work together on invalidity contentions, but Ford's argument was, well, this wasn't done by choice. It doesn't establish the significant relationship that Valve put forth as requiring this sort of discretionary denial. And so there, the director looked at it and said, yes, that's not enough for a discretionary denial under 314A. she came to a similar conclusion in General Motors v. Neo Wireless. It was sort of the same set of facts, extended again. Videndum was a little bit different, but it was considering the same significant relationship and the application of General Plastic. There, the board had actually agreed that there was no significant relationship at all between the two parties. And despite that, the board or the panel went on to consider the remaining General Plastic factors. And so the director said effectively that if there is no significant relationship and the parties are not the same party, they're not RPIs and are not in privy or not don't have privity, then General Plastic doesn't apply. And so that's kind of what we saw in the notice of proposed rulemaking, that would be sort of the standard before we apply General Plastic. But I agree with Scott. I mean, that's where the law stands right now, but it's not really clear what it will be once we have a new director. And so, I think potentially for the next year until we have a new director, that's where the law will be, but I think it's possible that things will change soon.
Scott, since you're up in there, what do you think we're going to see moving forward? I mean, is this a decision you think has some legs, or is it just this was Kathy's decision and now somebody else who, untethered by that being precedent for them as the next director, might choose a different path?
Well, a lot of these are very fact-specific, right? And the question that all of these cases get to is, well, when is it fair for someone else to come in on and challenge a patent that someone challenged first, right? This concept of serial petitioning. And so we've come up with this term serial petitioning. In the context of a multi-defendant suit, you wouldn't refer to a defendant as, right, a serial invalidity arguer or something, right? Everybody gets their day in court, everybody gets their invalidity argument, but the question is, well, when is it unfair for companies that are grouped together in this multi-defendant litigation, multi-district, whatever it is, to come in around, generally the same time frame. One petitioner comes in, the second petitioner comes in 7-8 months later, and that was really what this case was about. And if you look at the decision, well, are these companies really playing, together, or is it the same game plan? And some of the factors that were pointed out as well. They have different products, they have different claim construction theories. Yeah, they're grouped in the same case, but are they really acting together? And this, is this piling on the patent owner, or is this just like the normal course of litigation where everybody gets their day in court and their their shot at the patent? So, when my prediction when the next director comes in and is more aligned with what we saw under a previous Republican administration and trying to tamp down on some of these 314A practices, you probably will see another memo come out from that director. Unfortunately, some of these FinTIP practices are not in regulation, so as the new directors come in, they can swing that pendulum back and forth as much as they want. And the director review mechanism has become the way to make policy, because it takes too much time and effort to get the regulations across the finish line. And when you have directors coming in 18 months into an administration, you really need to know what you want to do before, right, you do it. You don't have time to sort of do the requests for comments and all of that, because it just takes too long. So I would expect to see some changing of these policies, whether it's initially through memorandum, and then, as Director Vidal did, sort of plucking off cases that address some of these issues and making that sentiment clear by way of those decisions.
Jay, thoughts on that? I mean, you were there, sort of, I guess. Well, the director review wasn't a thing when you were.
No, it was not. In fact, I probably would have fought awfully hard against it.
Yeah.
but
well, let me ask you that. What would you have advised? I'll tell you what I would have advised. What I have advised. Do you want to go first? Or you want me to?
No, you can go first.
I have, and I think this may come up in our next panel a little bit as well, but I don't think that Arthrex requires the director review that we have right now. I think Arthrex requires that we have a director that is the ultimate, the buck stops here. Now, the train may never actually stop at that particular station, just has the ability to stop at the station. And I think that Kathy, who I liked a lot. I think she did too much, and I think it's just not the director's place to be saying, well, I wouldn't combine these this way, or that I'm not sure that teaching over here in that reference is right. I think it should be the big policy things to steer and not to say that the PTAB doesn't get things wrong. I'm sure they do. You can't have 270 judges and they get everything all right in every grouping of 3 panels. But I think you have to have an intermediate body to do error correction. And I don't see anything in Arthrics that would prohibit the Patent Office from saying, we're going to have an intermediate body, like real formalized, and then the director, whoever the director is, can pick from those cases the ones that he or she thinks, well, I want to polish that for this reason.
Well, I mean, you go all the way back to Allopat, right?
Yeah.
I don't like the way this is coming out. I'm stacking the panel, and I'm going to come out. And that was legal, right? But the thing about it is, it's all transparent, right? When you got the commissioner for trademarks and the commissioner for patents on the case, that they're selecting how this case is going to come out. But the thing, Scott touched on it briefly, but it's evanescent what we're doing now, right? You have a director review decision. Okay, the current judges are going to go, okay, that's how the director thinks, but is it precedential? Is it, maybe it's informative in a certain extent, but has it been made one of those other classifications of cases? If not, it's just another case. But I've heard it said that the judges ought to be very careful to pay close attention to these cases. But what is that? I mean, that will change when there's a next director.
Yeah.
So I don't like the ability for it to whipsaw when there's a political change. I think that really detracts from the predictability of things.
Well, let me ask all of you this. Is the predictability, and these are maybe 2 separate questions, is the predictability at the patent office what you would like, or is the predictability at the PTAB what you would like?
Well, you're looking at me, so
well, you brought it up.
I'll take a whack at it.
Yeah.
I
want all of you to answer that if you.
When you're giving a client advice, they would really like to know how this is going to go, and if you're trying to tell them that you have a certain amount of percent chance of having this instituted or a certain percent chance, and it's never the same case twice, right? You've got a related litigation, you've got other parties that you've been talking to, maybe there's negotiations off to the side, somebody's settled. It's always different, but it'd be really nice to know where it's going to come out because the client wants to know, wants some degree of certainty so they can base the business decision on where to go on that. Mm-hmm. So yeah, I think it's really important.
Yeah, but is it satisfactory at the moment, or do you think it could be better?
Well, I mean, I would like to see if there's decisions that need to be made precedential, they get made precedential. I don't think we've had one in a while, which,
right.
That would be useful if the director, in addition to doing that, would have it set up for precedential consideration. But then again, those are evanescent as well, right? The next plate, well, that's not precedential anymore, or didn't take that one down. So to your point, I think codifying certain aspects of this are the most significant way to make it predictable.
Yeah. Absent a Ouija board, right?
I mean, I think the PTAB is very predictable when it comes to merit-based issues. When you're talking about questions of obviousness or how the board's going to interpret different presentations or different arguments. I think where it becomes a little unpredictable is when you get into matters of discretion, 314A in particular, and I've never been a fan of that discretionary practice. I mean, certainly the agency has discretion when you talk about 325D. Have we seen this art before? Or is this a waste of our resources because it seems like there's something going on here that we don't want to encourage? I'm fine with all of that, but when you start talking about FinTIV in particular and you have individual judges sort of substituting their own idea of, well, I think this is how the patent system should work, right? This is the overarching policy that I think we should have. I think that, right, if we're in Texas, that the trial should go forward. I mean, those are all policy determinations that I would prefer to see the legislature, decide. I think they would argue that they've already decided them. We've looked at timing. we came up with this mechanism to improve upon inter partes reexamination. Everybody was going to the agency late, waiting until after verdicts or after Markman. So we have a 12-month window. We want you to go to the agency if that's the resource that you want to use. So they've already spoken to this, in my view, and so it's always bothered me that the Patent Office, at least in my view, yes, you have discretion, but when you apply that discretion to basically swallow up the AIA and ignore some of these other specific time bars that the legislature's put in there, in my view, I'd rather see Fintiv just let's get something in legislation saying, here's your time period, that's your predictability. You can file it if you're in this window. There's no question in terms of where's the better place to move forward. What do we do in terms of competing jurisdictions? I'd rather see that come through the legislation.
Okay. Ingy.
Yeah, I'm going to echo a lot of what was already said. I do think predictability is really important. It's important when advising clients. I think clients want to know. I think the PTAB is predictable on the merits. It's mostly on the discretionary issues that you can sometimes get a surprise. So for instance, 314A, certainly there's a little bit of unpredictability there. But also 325D, the treatment of prior art that's listed on an IDS, for example, it can be very panel dependent on how that's treated and whether that is enough for discretionary denial or not. And so, it can be, it can make it difficult for clients to know, is this something worth investing money in or not?
So how are we almost, 14 years into this experiment and we don't know whether something that was on an IDS is enough for an IPR? I mean, is this a function of, and Scott, we've talked about this a lot, like it seemed like, and we have Director Campos is in the audience here, and I think we all expected, and I know you did an interview with me at times saying that you knew that you weren't going to get it all right. You had to put this whole thing together in really about 10 months because you had OMB have time to look at it over and all the rules and regulations. And so you had 10 months to create out of whole cloth. But then it didn't feel like there was any effort really until Andre was there to look at the rules and say, well, do they need to be tweaked? Is this a function of we went too long without making any changes and now we need to make some tweaks everywhere? Because that seems pretty fundamental to me.
I mean, it's one of those issues that if you're a judge that has prosecution experience, you're not going to be impressed with the fact that there's a reference listed on an IDS. On the other hand, if you come at it more from a litigation perspective, it's listed on the face of the patent, right? If you're in the district court, no one's using that reference for the most part. So you have a different collection of experience at the board, and I think that sometimes that's what drives, some of the differences in opinion on something like that. But, could there be more regulation? Sure. The problem is we keep running into is how long that takes. Mm-hmm. Let's get a director in the door now, and we can get some of those regulations. If you come in with 2 years, like I said, you just don't have the time to get those across the finish line.
Right. Jay?
Well, the problem with something that's just on an IDS is it reasonably likely that it was meaningfully considered? You figure it out.
Well, see, and therein lies the problem, right? I mean, because we all know, anybody that has prosecution experience knows a lot of the stuff that it goes on the face of the patent, the examiner never even really considered it at all. But devil's advocate, it may have gone on there, and the examiner may not have considered it at all, other than like when they used to flip through the shoes like this, they're saying in their mind, no, flip, no, because they know that box, that shoe box where all the art is.
Right, but no one knows column 57, line 38. So.
Yeah, but but okay, so then that gets us into a conversation about what is or what should be obviousness, right? Like how much is enough? Like if the patent has on the face a picture of eyeglasses, and then in one paragraph somewhere it reads potentially on an iPhone camera, this seems to be what the patent's about. Would somebody use that? And we don't have an answer to that, even that question, right? There's reasonable minds can disagree about something like that, which. And going back to where I wanted to say this when you brought up Allopat, yeah, it's similar, but it's very different because in Allopat, the question was, do you get a patent? Mm-hmm. And I'm not sure I like the idea of stacking the panel at all, ever. But I could make an argument in my own mind that that was justified because we got to decide. The office has to be, like Andre would say, office speaks with one voice. We have to have an answer, right? So we're going to stack the panel. We're going to make an answer. It's going to be definitive. I have a real problem stacking the panel when it's me versus you. And then it's the director or the chief or whoever, putting their thumb on the scale at that point.
Right.
And, it just seems, but there's so many of these things that are fundamental that we don't have any answer for yet. And it's mind-boggling. It goes back to Ingy, what you were saying, certainty. How do people know? How do they know whether they have a real chance? Patent owners or petitioners.
And that's where I think the director review has come in to try to answer some of those questions. And yes, it's not precedential, but the director comes in and says, well, we've got two ways to go here. We can say that it's considered, or we can provide, well, maybe it was considered if it was discussed on the record, and there's evidence of consideration. And it's just a matter really of picking one, and of at least a voice from the agency saying, well, this is how it is, maybe at least for now, but this is how it is.
And so this is really, it just bothers me a lot, like these decisions. It feels like in our space we're starting to get whiplash. Would you agree, like, it was this way, then it wasn't that way, now we're probably going to go back to the way that it was when, some people like, and it's, with this whiplash mentality, we're talking about an asset that can last almost a generation. And in certain areas, like in the pharmaceutical areas where we're talking to some folks about pharmaceutical patents, from the time that they're first filed, with the delay that it might take to get the patent issued and the extra term you get because of the FDA delay, it's going to be more than a generation from the original filing date. And what matters at the back end may be totally different, almost certainly will be totally different than what any of the inventors thought they had when they first filed the application. And layer on to that level of uncertainty in the unpredictable arts, for example, this changing, Republicans got the director's chair, so they view it this way, and Democrats have the director's chair, and they view it that way. Once upon a time in our space, it wasn't political. It seems like it's becoming political, not in that more philosophically political, because the Democrats seem to have one way to look at it anymore, and Republicans seem to have another way to look at it anymore. Agree, disagree, any of that?
It's American politics is the Hatfields and the McCoys, and
no kidding.
And every agency is immigration would be an example of just completely fundamentally different viewpoints. And I think for a while the patent office was somewhat insulated in that, not that no one cared, but no one that voted cared, and so therefore the politicians didn't pay too much attention to it. But that's changed, and so now we're seeing essentially what the other agencies are seeing.
Mm-hmm. Anything to add?
I would just say I think we might have to wait to sort of see how the politics impact the PTO and the director. I do think it's likely that we'll sort of revert back to Director Iancu's style, but there's some indications that that's not necessarily what we'll get. We've seen Elon Musk has very strong views about patents, and those aren't entirely aligned with Director Iancu's views. And so, there is a little bit of unpredictability even there.
Mm-hmm.
I guess my thought is, if we're going to have a process, whatever that process is, that it's fundamentally fair and open and transparent, right? Like, I have one bone to pick with the director review process, right? There's no reply or responsive right. You could go through a whole proceeding and then somebody files one paper and people who aren't familiar with the case are going to review it, right? So why can't there be a response from the other side before that process kicks off? I worry that too many things can happen if you don't have both sides in front of the decision maker.
Mm-hmm. Yeah, I know. And last year, Scott, at this program, what everybody was talking about was how sometimes there are certain filings made at the PTAB where you tell your clients, well, you're not allowed to do that. Mm-hmm. And then somebody goes and does it, and then the courts, the judges are like, oh, okay, we'll let that slide, and it makes you look bad. And it feels a lot more like the PTAB in some ways is more similar to state court litigation, where it's kind of, fast and loose, and well, I haven't gotten around to considering it now, so you can go ahead and file it, I'll put it in, and not as much like the federal courts where it's, sorry, you missed, you were supposed to file this by midnight and it's 12:04 a.m., unless everybody agrees, I'm not going to consider it. And that doesn't feel like what goes on at the PTAB.
I mean, by and large, most people play by the rules. I think where things go off the rails a little bit, and this is, I think, unique to the PTAB, is you have plaintiffs' attorneys, for example, come in. Maybe they're at the PTAB once every 3 or 4 years, and they're not going to see this judge again, probably, right? So there's a sort of lack of respect, or I don't know if it's consequences, but for example, you'd file a director review. Day later, this 2-page email gets sent to the same mailbox saying, well, everything that guy said is bullshit, right, cousin Vinny? And it's just all of these arguments, and it goes to the same mailbox. Nothing's ever going to happen to that attorney for doing that. And so you see things like that happen a lot. And, would they do that in the district court where they're going to see this same judge for the rest of their life? No. So it's a little bit, unique to the PTAB in that, it becomes, well, what's the worst that can happen? I'll get an email and it'll say, don't do that again. But I got all of my clients' arguments in. So, if they can get away with it, they'll do it.
Yeah. Jay, when I was going through that, I saw you almost roll your eyes at me. Or what was going on in your head when you were when you were thinking something?
Well, what I was thinking is you haven't had Judge Jameson Lee
Well, true.
issue sanctions against you.
Yeah.
There are exceptions.
Yeah, there are exceptions. But then that also makes it tough to know, too, I suppose. Well, I mean, it's good for those of you who are in front of these judges all the time. You know what you can do and what you can get away with. But all right, let me, and if anybody has any questions, please feel free to, Jim, go ahead.
Hi, Angie, you mentioned panel dependency. I've looked at the statistics and seen that it's like a bell curve, but some APJs rule for patent owners 90% of the time, and some others rule for petitioners 90% of the time. And these are people with a lot of cases under their belt, like at least 50 cases. So there's a difference in viewpoint there. My question for the panel is, what, if anything, should be done about that?
I mean, you could make the same argument for examiners, right? There's some that advertise on their door that they've never issued a patent ever. There's others that, issue a lot of patents. I mean, obviously if they're outliers in the statistics, someone should be policing that stuff, but.
The statistics are funny things, right? Lies, damn lies, and statistics. Yeah. And, you're not looking at a completely genuinely random sample of cases ever at the PTAB, right? You've got ones that are selected by somebody who believes that there's a merit to the petition, right? They're not filing petitions they believe have no merit whatsoever, hopefully, because that would be a problem. So you've got, in some ways, the numbers that you see at the board in some way are elevated in certain ways, but then you also have people who are in certain technology areas where they're always pushing the limits of patentability. So there's so many ways to slice the data, and if somebody in the biotech area is allowing 90%, that might not be unreasonable if biotech is, the advances are extraordinary. And if it's in a software area and you've moved your cursor to a different shape and it's purple now, you might have 90% rejections. And I hate to just chop things up on a raw number and then throw it out there, because there's so many confounding factors to that.
I do agree with that. I think you can't just look at the numbers. It depends on the technology area, and in biotech and life sciences, for sure, I think, likelihood of success is always a factor. The other thing I'd say is, I think that's what director review is for, so that the PTAB does have an opportunity to look at the cases where there are outliers and there are cases in which maybe that wasn't the right result. So to me, that's sort of the solution, to the extent that there even is a problem.
Mm-hmm. And one of the things I really like about director review is there are those cases, right, where with absent that, there's no review at all, right?
Yeah.
A non-institution decision You now have an outlet. If you think you've egregiously been wronged, you can at least try again. I like reviewability of decisions.
So
Not too much.
I'm going to just be honest. I hate director review, and it's not because I don't want error correction, because I do. I mean, I think every system has to have error correction, right? It's just that it goes back to, Scott, what you were talking about, the amount of time and energy it takes to get even a small package across the finish line. Mm-hmm. I don't want the director reviewing for error correction. If the director sees and looks at this and has been convinced in communications with members of the bar and patent owners and petitioners that, one of these fintive factors is no longer relevant at all, then I want her or him to go and take a case and say, okay, well, this factor is least important, and kind of reorder it for everybody. I want the big picture items and have somebody else whose job it is to error correct, doing the error correction, so that we can actually get to the point where we're doing some good for the system. Because it takes too long to get these rules done. And the other thing I didn't like was I thought the advanced notice of proposed rulemaking was like, here's a list of what everybody is thinking, us included. Tell us what you like, tell us what you don't like. And that just sucked so much oxygen and so much time. Nothing was going to get done. And we talked about that. We knew nothing was going to get done. Or if it did get done, it was going to be 2 or 3 things. And what happened? It was a big nothing burger. Mm-hmm. Go ahead, Scott.
I mean, most director reviews are still getting denied, right? It's not as though the director is really getting into fact-specific cases and deciding, well, I looked at your obviousness showing, I found it persuasive, therefore I'm going to reverse the panel. It tends to be, policy level procedural issues that would cut across a bunch of cases. But there's a lot of them. So if that's the only way you have to change the direction of the ship, then you have to leverage it. And I think filers see this and it's like, oh, now I can file a direct review and re-argue my case. And so there's a lot of direct review requests coming in, but there's still probably 10% or less that are actually getting picked up and changed. So it's, that's something I expect to continue, not because Director Vidal was meddling or, interested in getting involved in every case, but that's the only real mechanism you have to make sort of instant policy changes. And so that's why I expect that to continue. Filing one because you don't like the outcome of your case, or you didn't think Exhibit 1020 was given the weight that you thought it should, that's just wasting your time. You can still go back to the regular panel for that kind of stuff, and presumably if it's a fact-specific issue, you can get your relief there.
Or the Federal Circuit. Mm-hmm. I mean, that's always there.
Yeah.
No, the Federal Circuit, the only time they ever seem to only ever overturn the PTAB is when the patent owner has won.
What? Oh, okay.
Am I wrong?
It can seem that way sometimes.
It can seem that way. I mean, it's not. It's an overstatement. I get it's an overstatement, but it does feel to me like there's oversight of the PTAB in one direction.
I don't know that I would say that. I'm going to say that the Federal Circuit does its job ably and competently.
Well, I'm already on the blacklist at the Federal Circuit. So. Go ahead, Judge Michelle.
How can you know the competence and thoroughness of a Federal Circuit decision if it affirms with no opinion at all?
You give the full faith and credit to a federal employee that they're doing their job appropriately.
Then why do you need opinions in any case? You make the same assumptions in every case about every decision by every panel.
Yeah, I'm troubled by how much the Federal Circuit uses Rule 36. I'm also increasingly, the older I get, and I know this is not new, but I'm increasingly frustrated by substantial evidence. I mean, if you went around, I wish we could do like a man-on-the-street interview with members of Congress and ask them to define substantial evidence. Because it sounds like to real people who aren't steeped in the law, or even not steeped, but haven't, like first-year law students who haven't taken an administrative law course, substantial evidence sounds like robust. It has to be a lot of evidence. And it's It means any evidence, any scintilla, no matter how tiny, to support what they did is fine. And I find it just off-putting myself, but maybe I'm alone.
Rule 36 is used extensively.
Mm-hmm.
But would it make anybody feel any better if the Federal Circuit started saying, well, we had this case, we read the parties' briefs, cut and paste, we really like this argument, and we agree with what the agency said here, cut and paste, therefore we affirm. Is that going to take them that much more time, and do you really get much more out of that?
You don't probably get much more out of it, but I think people would feel better. But I also think the argument that I've heard some people make, and judges, there's only a couple judges at the Federal Circuit talk to me. But so most of my information comes from clerks. But the clerks will tell me that the reason that they do Rule 36 is because they don't want to embarrass attorneys. And I'm like, well, embarrass them. If they're filing frivolous appeals, then not only embarrass them, sanction them, for God's sake. And I don't, so that I can't say that that's the official position of the judges, but I will tell you, I've been told that by more than one former clerk that we could be doing these opinions, but it would embarrass the hell out of some practitioners because their arguments are terrible. And I think that there is something to that, right? But I also blame not the practitioners who are making the crappy arguments. I blame the Federal Circuit, right? The Federal Circuit has gotten to a position where you've spent so much time, money, and energy to get there. Well, let's just throw it over the transom, because you want to talk about panel dependency and unpredictability. That, by definition, is the Federal Circuit. So we got this far. We might as well at least give it a chance. And I think they've brought that on themselves. So feel free not to comment on any of that, because...
Well, I mean, there may be some truth to, if some of these decisions start coming. I mean, you can listen to the recordings, and there are people that make some, pretty extreme arguments. And if we start putting things in writing about, attorney so-and-so made this argument, I mean, maybe it discourages those kinds of appeals in the future. So I guess there will be some benefit.
So, and that's precisely my point. If you're getting a lot of frivolous or borderline arguments, the way to stop that is to say, hey, this is a frivolous argument. Let me explain why this is a frivolous argument. Because this has been the law for 2 decades, and you've given us no reason why we should change it.
Yeah, when you have to come up with an APA compliant decision, right, which tells you everything, the reasons why you wrote it, you are forced into that. And sometimes I can say in the past when I've written decisions, I feel a little sorry for the attorney who I'm going to be excoriating to some extent on the fact that these are meritless arguments. Mm-hmm. I don't like to do that. But you got to do it.
You got to do it, I think. But why do you think that do you agree with me that people are making these arguments because, well, why not? Nothing. There seems to be no repercussions for making a crappy argument.
Okay, there are a lot of counsel, not a majority, mind you, but there's this healthy subset who use the spaghetti approach. Let's throw anything possible against the wall and see what sticks, and that is not efficient. And it's not, I know the board doesn't recommend it. Your top couple of arguments, please, not 27 arguments, because there's no way 27 arguments of error is persuasive, right?
Right.
But there are some attorneys who do that from time to time.
And I hear that more often dealing with PTAB issues. Is that a PTAB problem? Not to say like the judge's problem, but is it a problem for practitioners who argue at the PTAB in particular, or who appeal from the PTAB to the Federal Circuit?
Again, in my experience, I wouldn't say that. What it is someone who doesn't have actual PTAB experience a lot of times. Sometimes it's a prosecuting attorney who's thrown in front of the PTAB who doesn't really know what to do. So this is like prosecution, right? I'll throw everything in. Mm-hmm. But it's not the majority by any stretch.
I mean, that could be part of the dynamic too, is, a lot of times you get these, we'll just call them creative arguments, And then when it comes time
That's being kind.
when it comes time to stand there and argue, it's, well, let's get the junior attorney who has no experience at the PTAB or the Federal Circuit. Let's get them some experience. And
Yeah,
so-
no, I had one of those when I was just out of law school, and I got sent up to, I was practicing in New Hampshire, and I got sent up to like the furthest courthouse away. It was like, you could see Canada. You could practically touch Canada. And none of the partners wanted to go up there. And the judge came up to the podium, to the dais, and looked up and said, well, where's Attorney Kinnison? And I'm like, well, I'm here on his behalf. And the judge said, well, let the record reflect what I'm about to yell at Attorney Quinn is directed to Attorney Kinnison. So that does happen. It sucks to hear that it happens still at the PTAB. though.
I will say, I think at the Federal Circuit, I don't think it's limited to PTAB practitioners in terms of the throwing the spaghetti at the wall approach. I think that happens a lot at the Federal Circuit. I also, I would be surprised if the reason that we have Rule 36 judgments is because they're worried about embarrassing practitioners. I just sort of haven't necessarily seen that in the decisions. I think it's more of, a Rule 36 judgment in my mind is saying, well, we agree with the board. And to the extent that we now require, or we decide that, no, the Federal Circuit's going to be required to draft an opinion every time they adopt the board's decision, that's just going to slow down the Federal Circuit, increase the backlog. And to me, that doesn't seem like a good result for practitioners. So I know there's a lot of controversy about this, but I haven't necessarily seen Rule 36 as a problem. There are a lot of non-precedential opinions from the Federal Circuit that we can't cite anyway. So this, to me, seems like another non-precedential opinion that gets the decision out.
And a lot of times you have unreasonable clients that for whatever reason, either they just want to try to cost the other side money or what have you, and they just want you to play it out. And so I've had cases at the Federal Circuit where I was very thankful for Rule 36 because I didn't want to make those arguments, but it's part of the job.
Yeah. Any question? Judge Michelle.
I'd be interested in the panelist's view about whether they agree with the criticism of the Federal Circuit that it seems to be unduly panel dependent, and how would they compare that with the sense as to whether PTAB panel decisions are also unduly panel dependent?
I
Don't all
seen-
jump at once.
Yeah. I mean, my understanding of the arguments about panel dependence at the Federal Circuit tend to be more, we'll just say, apart from the typical PTAB top, meat and potatoes.
Yeah, no, it's not like PTAB versus district court. It's sort of
It's whether
philosophical.
questions of
Right.
112 or 101
Right, right.
don't seem to come up as much. But I don't see too much panel dependency at the PTAB either on some of those issues.
Yeah, not on the merits issues.
No.
That's pretty standard.
Mm-hmm.
Okay. Yes, Richard.
Yeah, I was just wondering, can anybody shed light on how panels are actually picked? I mean, is it a random process, or it seems like?
It's for you, Jay.
Yeah, seriously.
Judges in the back. Is that one that you can answer?
There's a standard operating procedure on our website that talks about the whole process of how we pick panels. It's all there based on a number of factors, including conflicts, interest, technical expertise, workload, and that all kind of goes into the mix. But looking at our SOP, and I always get the number confused, so it's okay, number one. So SOP 1 on the PTAB website, it should be easy to find. It has things, but I think it's written out standard operating procedures instead of the acronym on the website. So, yeah, you can, or you can use your favorite search engine for SOP 1, PTAB, take direction.
Thank you for saving us from that
Yeah.
question.
So just so the recording has it, the question was about how are PTAB panels picked, and Chief Judge Bullock said that they have a very detailed standard operating procedure on the PTAB website, and standard operating procedure 1 really goes through and explains how that happens. Dave, did you have a question?
Yeah, so I just, you guys can step back a bit and give us, if there were like one thing in the law that governs the operations of the PTAB, whether it's the, standard of review of claims or the issues that have come up with director review that you'd love to see, put into the code so the director does change? What would that be?
So the question is, what would you like to see put into the code or into the regulations to enhance the PTAB proceedings or procedures? Angie? Go
Yeah,
ahead.
I'll jump in. I would love to see the discretionary rules put into the code as much as possible. So the treatment of FinTIV, I would love for that not to go back and forth as the politics change. So it would be nice to just know, regardless of how it turns out, we just know here are the rules and here's what we're going to do. Similarly with serial petitions and parallel petitions and 325D. It would be just really nice to have predictability on those issues.
Including soteric stipulations?
Including soteric stipulations, for sure.
Yeah, I mean, that all makes sense to me. The idea of having either through legislation or regulation some kind of guidance on these issues. I'd go back to FinTIV in particular on, is that really the will of Congress for the agency to be exercising discretion, frankly, in an area that's a little bit outside their wheelhouse, right? They're typically not making those kinds of policy determinations at the judicial level, individual APJs. So something like that, some guidance on, whether it's codifying FinTIV or just clarifying whether it's something they should be doing in the first place, would make me happy.
Jay, anything in particular?
Well, the top two have been taken, so I'm just going to say, Dave, we wrote some good rules.
Okay, Kevin, I think I saw your hand.
Yeah, I had a question on just the role of Rule 36 in appeals from administrative agencies. I think, is it ever appropriate to use Rule 36 in an appeal from an administrative agency, given that the Federal Circuit can't affirm a decision on grounds that weren't actually invoked by the agency? Because I don't know about you, a lot of the appellees I face tend to throw an alternate basis for affirmance, that maybe the board didn't reach in a final written decision, even if the prevailing party had put in evidence on that in front of the PTAB.
So whether or not they should clarify that the affirmance is based on the record as compared to some additional argument that's been added.
Yeah, because when I look at it, I think the requiring a written opinion is a guarantee that the appeals court has complied with the Chenery Doctrine. It's not affirming on grounds that the agency didn't itself invoke.
Yeah.
I guess if there's something left hanging out there undecided like that I would actually think that a Rule 36 shouldn't be the vehicle. I would agree with you there. And it's best to have it all dealt with in one package.
I mean, I'm comfortable that the court is, certainly looking at the record that it's accustomed to looking at and not affirming on those grounds. But I think most of the criticism with Rule 36 as well, for the record that is appropriate, what is the aspect that you're sort of endorsing, which we don't get.
That's my instinct as well, that if you get a Rule 36, it's not on an alternate ground that the board didn't consider. That's sort of the way I read them.
Yeah.
Well, it's not, I don't think it's supposed to be. I mean, you're affirming what the board did.
Yeah.
That's what it's supposed to be.
Yeah, it's just like the number of times I've seen appellees just, throw in alternate grounds of affirmance that maybe the board didn't reach, even if, that evidence wasn't the record from the PTAB. It's hard to explain to a client when you get a Rule 36 that, this is what happened, it's affirmed without opinion, we don't know if Chenery was followed. I think for me, it's more about the appearance of justice rather than, substantial justice, because, I have no doubt the processes are being followed, Chenery's being followed appropriately. But it's really more for clients, for the patent system as a whole, that we see this transparency.
Judge, go ahead.
Angie made a very thoughtful point, in my opinion, about whether decreasing the reliance on Rule 36 no opinion affirmances would increase the delays. The delays currently are really quite serious. In my opinion, they're way worse than they were 20 years ago. But when we talk about an opinion versus a no opinion affirmance under Rule 36, it's easy for people to assume that you're talking about some lengthy, scholarly, time-consuming writing exercise. I sat many times in the 90s with other circuits that were shorthanded, particularly the Second Circuit in New York. And they had a practice which I thought made a lot of sense. And that was to issue per curiam opinions that would typically be 3 or 4 pages. They were quite informative. You had a real clear sense of what the ground of decision was and why, and a little bit about what was wrong with the arguments of the losing side. And that, I thought, was quite efficient. It doesn't take very long when you've gone to the trouble of read the briefs, look at the record, particularly if you've also heard oral argument, which the Federal Circuit does. In almost every case, if there's an attorney, only pro se cases historically have not had oral argument. So it seems to me that in terms of whether Rule 36 practice or frequency should be reduced, it could be reduced without materially adding delay if it were done on that kind of per curiam 2 or 3 page opinion, I submit.
Yeah. No, and that was when I grew up in the law in New Hampshire. That was what the New Hampshire Supreme Court did, is every case had at least 2, 3, 4, and it can be as simple as the last paragraph say the other issues raised were found unpersuasive, but like the major arguments you don't need to, like with some of these things, it's so well established. You could just cite the case. We find this party's side persuasive because of cite the case, and it's something. It's some information. I don't understand why the Federal Circuit has a backlog. Any backlog. I mean, this is going to be really controversial, probably, and not necessarily the right panel to do it. Maybe we'll have the right panel later on, but what I understand is that the Federal Circuit production is much lower than the production at other circuits. And I looked at it some time ago, and the Federal Circuit is pretty near the bottom in terms of production and the number of opinions they issue and that sort of thing. Now, you might say in some of these patent cases they're very complicated and so forth, but if you haven't noticed, the Federal Circuit has really become a veterans court. Overwhelmingly what they do are veterans cases. And less than about 24% of what they do are patent cases. And they only issue precedential decisions in about 6%. 6% of their precedential decision, no, 6% of their workload are precedential decisions in patent cases. So I don't know why they have such and I've been told by clerks from other people who have clerking experience from other circuits that what is expected of the clerks at the Federal Circuit is much less than what's expected of clerks on other circuits. Now, I don't know whether that's true or how. You're shaking your head.
So I don't think that's true.
Okay.
I mean, I clerked at the Federal Circuit, and I've spoken with clerks at other court. I think the clerks work extremely hard. I know the judges on the Federal Circuit work extremely hard. So I haven't looked at the production numbers, so I can't speak to that. But to the extent that there is a difference, I imagine that it probably has to do with the types of cases. And even if there aren't that many precedential opinions, I know that they treat non-precedential opinions just as seriously. And so I'm sure they're not less time consuming. So, I can't really speak to the numbers, but that's my instinct.
Gene, another point of comparison is what are the delays at the Federal Circuit today compared to 20 years ago? And that is a very big difference.
It is a big.
It was the norm when I left the court in 2010 that a case would be scheduled for oral argument within a few months of when the record was complete. I'm now working on some consulting cases where it's over a year since the record was complete before there's even an announcement of when the future argument date will be, and that's still another couple months off. So if you look at the history, delay is a way bigger problem today than it was 20 years ago.
Yeah, it is, and I don't know why that. I think. I mean, if I had to guess why it would be, is if you look at, and I think you were alluding to this earlier, is when you read some of the Federal Circuit decisions, they seem more like law review articles rather than just trying to decide the issue in front of them. Back in the day, you decided the issue that was in front of you, and if the decision was 5 pages, it was a decision with 10 pages. Now, with some of these decisions, they're 50, 60 pages, and then some of them, with all the concurring and dissenting opinions, 100, 150 pages, and it's like, whoa. I think we would do better to have more decisions across the board. It would be more informative to the industry. Myself, that's my own personal opinion. But
Do you think that would open the court to more requests for reconsideration or rehearing or any of those things?
I don't know. I mean, this court particularly doesn't seem interested in rehearing or en banc at all very much. And the cases they've taken en banc kind of make me scratch my head. Like Google lost $20 million and they're taking that en banc. I mean, that doesn't seem to me to be and if it's the right issue that needs to be decided en banc, maybe you should wait for the issue to present in a more financially inconsequential manner than, one of the richest companies in the world losing $20 million. That's sort of my take on it. But so I see we've gone about a minute over, but I'll give each of you one last chance to summarize your thoughts. If you have any thoughts, anybody have any parting comments, something you hope people remember? Jay, it looks like you want to.
Yeah, sure. I'll go ahead. I like transparency. I always like to see, and that, you had said earlier on, you thought that the ex parte Chamberlain case was important.
Mm-hmm.
I'd like to hear why you thought it was, because I like that they went through we wanted to reconsider this, so we brought it back. I like that. I like seeing the why. That makes me very happy, the transparency.
Yeah, my reason for it was I thought it was substantively, I thought it was important. I mean, you see in that case attorneys trying to, I think, take into account the Amgen decision, right? Is that we're talking about the same Chamberlain case, right?
Yeah, it was immunoglobulins.
Right.
Yeah.
So they're looking for claim strategies that maybe will suffice, and I think that the board actually gave some meaningful guidance to patent practitioners. If you read that, you can see that and say, well, this won't work, but this may work. Well, anytime you have any court on any level give practitioners that kind of guidance, that no more of that, but give me more of this. This has got real legs. I think it's a good day for the court and a good day for the industry. Scott?
I think I'll be spending a lot of the second half of the year with my fingers crossed on, in terms of who ultimately gets through Senate confirmation and those petitions that I'm filing in July and August that 6 months later will then be determined under this new standard, whatever it is what I'll be worried about.
Mm-hmm. Well, good. And Inchi?
Yeah, similarly, I was just going to say, I think we are sort of in a point where we don't know what the future is necessarily going to look like, and it's going to depend on who the new director is. So we'll find out probably halfway through this year or late this year.
Yeah, very good. Awesome. Well, great. Well, thank you very much.
Thank you.
Thank you.